roll call, please.
Dr. Bolak?
Present.
Dr. Nanadez?
I'm sorry. Here.
Ms. Lawson?
Here.
Dr. Levine?
Here.
Ms. Pines?
Here.
Ms. Sutton Willis?
Sutton Wells here.
Excuse me, I'm sorry. Dr. Kraus?
Present.
We have a quorum.
Thank you. Before we proceed with the first oral argument, it's that time of year for this panel to have elections of chair and vice chair or their nominations.
I nominate Dr. Bolak, Chair.
Any additional nominations? All in favor? Congratulations, Dr. Bola. Are there nominations for vice chair?
Nominated.
Ms. Dobbs?
We need a roll call vote for that.
I'm sorry.
We need a roll call vote for that.
Okay.
Dr. Bolak? Aye. Dr. Nanadez?
Aye.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Dr. Kraus?
Yes. Nominations for vice chair?
I nominate Christina Lawson for Vice Chair.
Any additional nominations? Roll call.
Dr. Bolak? Aye. Dr. Nanadez?
Aye.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Dr. Kraus?
Yes. Our first oral argument today will be in the case of Lee County Wynn. I'd like to introduce Judge Susan Boyle. Judge Boyle will provide instructions for the argument.
Yes, thank you. Good morning. We're here this morning on a petition for reinstatement of Lee Kwan Nguyen. This is case number 800-215-014-647. Today, the oral argument relates to the board's determination to non-adopt the proposed decision. May I have appearances, please?
Yes, good morning, Your Honor. Kevin Cawley appearing on behalf of Lee Nguyen. Mr. Nguyen is present before the court.
Greg Chambers for the Attorney General's Office, representing the Medical Board.
Respondent will have 15 minutes to make his presentation, followed by the Deputy Attorney General presentation, an additional 15 minutes. Respondent will then have 5 minutes for rebuttal or further argument, and then closing argument by complainant by the Deputy Attorney General in 5 minutes. All right. If Mr. Nguyen proposes to make any statements, he'll need to be put under oath. Does he plan to make any statements?
Yes, Your Honor. Could we do that at this time?
Okay. Please raise your right hand and be sworn. Do you swear or affirm the testimony you're about to give this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Collins, your time starts now.
Okay. Good morning, Your Honor and honorable board members. We'd like to, first of all, thank you for granting us the opportunity to appear before you here this morning. We're here today in response to the board's non-adoption of a proposed decision reinstating Lee Nguyen's California medical license. We are respectfully requesting that this panel uphold the ALJ's proposed decision, including the proposed penalty, which reinstates his license subject to a 5-year probationary term with conditions that he complete a clinical training program, refrain from solo practice, and have substance abuse recovery monitoring under terms required under the board's uniform guidelines. We'd like to note that in reviewing the proposed decision and findings of the ALJ, that the California legislature has codified an express intent that the board give great weight to the ALJ's factual findings. At hearing, petitioners submitted nearly 200 pages of mitigation evidence and introduced testimony from 3 witnesses, including an expert witness concerning his recovery efforts and current ability to practice. He has submitted overwhelming evidence of rehabilitation as indicated in the record. I'm just going to highlight a few things. I don't want to go through the entire record. But the 2008 conviction that formed the basis for the revocation of his license has been dismissed. He has had no further arrests or convictions. He has engaged in extensive recovery efforts including completion of a 6-month outpatient recovery program at South Coast Rehab Center, attendance at NA and AA recovery meetings 5 to 7 days per week, active involvement in a 12-step program, engaged in random drug testing, and participation in the Pacific Assistance Group monitoring program for impaired healthcare professionals. At hearing, Dr. Gregory Skipper, Director of the Professionals Recovery Program at Promises Treatment Centers, testified concerning his evaluation of Lee and confirmed that Lee is fit to return to practice under terms that require monitoring. The record also clearly indicates Lee's involvement in the medical field and desire to regain his license. Since the 2008 revocation of his license, Lee has devoted his time and energy to Automatic Subdermal Injector System Corporation, which is a medical device company that he founded. ACES develops and holds patents for medical devices. He has expressed a willingness to regain his license at this time to further his work with that company. He is also engaged in 150 hours of continuing medical education units. He is engaged in extensive research related to his medical devices and published 3 articles. He has also completed a Bailey review course. At hearing, Lee readily acknowledged that he has been out of practice for 7 years and will need to retrain. At hearing, Lee brought forth, upon direct examination, the fact that he is willing to enter into the PACE program as he realizes that that's something necessary for his return to practice. With regard to the penalty, it should be noted that the order imposed by the ALJ is consistent with both the board's manual of model disciplinary guidelines and disciplinary guidelines and exemptions for uniform standards related to substance abusing licensees. Now, complainant has indicated that it believes that additional conditions may be necessary. In pertinent part, complainant, through its legal counsel, has urged the board to include a surgical proctoring requirement. This requirement is based in part on the fact that Lee has been out of practice for an extended period of time, but it's also based in part upon the fact that he was disciplined in 2005 following an incident which resulted in injury to a patient. What it neglects to state is that as part of that decision, which he successfully complied with, he completed a mini residency program in endoscopic surgery at the University of Pennsylvania. Per the terms of the decision and successful completion of that, the board did enter a reprimand. So it's inaccurate to say that he has not engaged in any remediation for that event. So we would respectfully contend that that condition is not appropriate and ask the board to omit it from its order. In addition, we believe that the PACE program will assess Lee's skill, should his license be reinstated with the PACE requirement. The PACE program will assess his skills and make recommendations for any necessary education or clinical training. We would also just point out that this requirement is not consistent with the board's guidelines. At this time, we would like to address the board.
Good morning. I would like to take this opportunity to thank the Medical Board of California for affording me the opportunity to be here today. My life went out of control in 2006. My 7 years of marriage that resulted in 2 beautiful daughters drastically came to an end. This event brought me a lot of anger, resentment, and together with my poor judgment at the time, kind of led up to use a drug, namely cocaine, and eventually resulted in my arrest and loss of my medical license. Following the loss of everything that I cherished, I set out on a long road to recovery. The past 8 years of recovery has taught me a lot of humility. Since my 6 months of rehab, course back in 2008. I embraced the Talk Test program, and I practice as a principal in all my daily affairs. I've worked this step many times with my sponsor, and I attend AA as well as NA meeting 5 to 7 times a week. I've learned the importance of letting go of anger and making connections to my colleagues and friends, both of which will help me sustain in my recovery. I also have been actively immersed in the Pacific Assistance Group with monitoring, and that's also where I get a lot of peer support. This humility has also has not only ensured my recovery, but has also reinvigorated my passion for the art of healing and the practice of medicine. Although I've been away from the practice of medicine, I have stayed in the healthcare field in other ways. My desire to provide service to others has led me to invent medical devices. I have 2 medical device companies and 3 patents, one of which is in the process of getting FDA approval, and I have 5 research protocols posted on clinicaltrials.gov. I do believe there's a second chance in America, and that recovery has offered me a second chance in life. I would appreciate it if the medical board would reinstate my license and allow me to return to practicing what I love the most, and allow me to contribute further to society with my medical devices. I stand before you today fully committed to comply with any terms and conditions that the medical board deem fit in order for me to return to work as a physician. Thank you so much.
Thank you, Your Honor.
Additional 6 minutes, okay? Jacobs.
Petitioner has provided evidence of rehabilitation and structure with regard to the issue of addiction. What he has not shown is structure with regard to the practice of medicine, and that's where the issue arises with the board, I believe. This is an individual who has not practiced medicine in 8 years. He has taken 150 hours of education classes, but he has not followed or shadowed a doctor. He has not done any clinical rotations. And as noted, in 2005, he did cut the carotid artery of a patient. He took a class, but again, he has not practiced since 2008. At that point in time, we have a diminution of skills. What we need to create is a structure for this individual, and thus we have recommended 25 proctored examinations where the petitioner is the assisting surgeon, and 25 where the petitioner is in fact the principal or primary surgeon. Without such a structure, we cannot have confidence that the public will be safe with this petitioner's skill set and level of competency. While pace may be acceptable for many things, we believe that a repetition of surgical skill shown before a proctor would be sufficient and necessary in this case. Thank you.
Mr. Kelly, you have 5 minutes left.
Just briefly, if I may. We're not here before the board today asking for an unrestricted license. Lee is well aware that this board is going to impose conditions upon this license. One of those conditions will be the PACE program, which will provide an individualized and particularized assessment, complete with recommendations for any education or training in the areas of deficiencies. We believe that the public can adequately be protected through this provision. The condition proposed by complainant would be extremely difficult for petitioner to comply with. given the number of procedures as well as the fact that he has been out of practice for 8 years and is not credentialed in the facility, it's going to be very difficult for him to find a situation where he can comply with this requirement. Whereas if he were to go through the PACE program, even if PACE determines that this is necessary in order for his rehabilitation, they're better equipped to place him in a situation to comply with those requirements, which he would be required to do as a condition precedent prior to resuming practice. We have nothing further at this time.
Chambers?
Nothing, Your Honor.
Is there an opportunity for Dr. Lynn to answer questions from board members?
Absolutely.
Dr. Ganadis?
You are an otolaryngologist, ENT surgeon at Canada, right?
Yes, otolaryngology is my specialty.
You haven't been out of surgery for 8 years.
Yes, that's right.
So how confident are you, or can we be, that the public will be safe when you haven't done surgery for 8 years and you're asking us to release this requirement? My only other question I would have is the next one is that, can you secure a 3 or 6 months of additional training somewhere? But we're just worried about the PACE measures your skills in diagnosing, treating, and all, but PACE does not measure your technical skills. That's the one problem we have with PACE program. So that's why I'm just wondering why you have such an issue with that. So at least personally, I'll be okay with the condition we proposed, or if you can secure an additional training program for at least 3 months.
I believe my technical skill is still intact. When I was at UCLA, I was the top surgeon there. The chairman generally called me in the OR to finish the case. And I generally do the cases half the time that other surgeons do. I've done surgery since I was 24, up to 8 years ago, so that's over 20 years. More or less, I can do cases with my eyes closed. Forgive me, you know. But out in private practice, we're not doing big cancer cases anymore. Just routine, common cases like PE2, tonsillectomy. I've done thousands of those. It's like riding a bike. It's not that big of a deal. I'm willing to be proctored, but I feel comfortable getting back into this thing. If the PACE will allow me to perform surgery while you watch, that'll be great. That'll be the perfect setting. Out in private practice, it's really hard to get other people to watch me do a case. Take time out of the practice. But I will comply with whatever the board recommends.
May I address one thing just really briefly on that issue too? And again, it's not an issue. Again, we have expressed he is willing to accept whatever conditions are deemed necessary. I think the concern is the ability to comply with it. And as written, you had mentioned a training program. If there were an option for a training program, that may be something that's much more likely for him to be able to comply with in a timely fashion than finding a situation where he can fulfill the requirements of the 25 and the 25 procedures. I'm sorry.
I just wanted to clarify that because when you made your original presentation, you said he's interested in gaining his, Dr. Lee's interest in getting his license was to continue to participate in the company. But it sounds like your real intention is to return to being a surgeon. Is that correct?
That's my primary goal, yes.
And is your intention to eventually be in a solo practice?
Eventually, yes. Not immediately.
Brenda?
Yes.
Doctor, your counsel spoke to the barrier that you might, your counsel spoke to the barrier that you might have in getting proctoring, but said that with PACE, that through PACE, you might be able to have access to proctoring. How do you understand your ability to be proctored?
I haven't been there yet, but I imagine they would have professors I can follow and watch case or assist and actually do the cases while they watch. I imagine they should have something like that, and I'm willing to participate in that.
Is there a significant harm to your practice to being proctored?
I'm sorry, repeat please.
Is there a harm to your practice to being proctored? Would there be a harm to you to have
I
a
don't
proctor?
think, being proctored, no, I don't think so. I've been proctored before. When I first finished residency, before getting hospital staff privileges, I was required to do 5 cases to be proctored. That's generally the case. 25 cases would be a lot of work for me, but I will comply.
Thank you. We'll adjourn for a closed session.
Thank you very much, everyone.
Argument non-judicial reprimand regarding Dr. James Edward Odorizio. Speakers. Judge Boyle.
Thank you. I'm going to call the matter of the second amended accusation against James E. Odorizio. This is case number 12-2011-217-415. OAH case number 2014-080414. May I have appearances, please?
Martin Firestone on behalf of Dr. Odorizio, who's next to me.
Carolyn Evans on behalf of the complainant. James Egg Simon, also on behalf of complainant.
And who will be making the argument?
Ms. Evans will be making the argument.
All right, so we're here today on oral, for oral argument after remand from the Superior Court. If Dr. Odorizio intends to make any statements, will he be under oath?
Yes, he is.
Is he going to make statements to the board?
Yes, Your Honor.
Go ahead and swear you in now. Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Counsel Firestone, this file will have 15 minutes to present its arguments. The Deputy Attorney General will then have 15 minutes for their presentation. And it comes back to you, Mr. Firestone, for 5 minutes for closing statement and then 5 minutes for closing statement for the Attorney General.
Your Honor, I will probably take less than 15 minutes. I would like to reserve the extra time for Dr. Odorizio to make his statement, if that would be okay.
Yeah, it's fine. And you can divvy up your 15 minutes as you wish. And I will give the parties notice when we have 2 minutes left, so you know where you're at. All right, Mr. Firestone, may I begin?
May I just ask one question?
Sure.
Would you like Dr. Odorizio to give his statement immediately after mine or after Ms. Evans gives her argument?
I'll leave that up to you, but your
Okay.
time limit will be the same.
Thank you.
All right, proceed.
Good morning, ladies and gentlemen. My name is Martin Firestone. I have the privilege and honor of representing Dr. James Odorizio, who's at my side. The Honorable Judge Joseph M. Quinn of the Superior Court determined it is necessary for this board to reconsider its prior penalty in light of the findings that he reversed. In the decision and order adopted by the board on August 24th, 2015, from the probation terms were taken by rote from the board's manual of model disciplinary orders and guidelines. The board is
at this time, is not required to follow its recommended range of penalties for violations. This is stated in the manual on page 25. Instead, the board can and should tailor the penalties to the individual circumstances of each case. And, as stated on page 6 of the manual, the board must consider, and I quote, mitigating or other appropriate circumstances such as early acceptance of responsibility, demonstrated willingness to undertake board-ordered rehabilitation, and the age of the case, end of quote. The board's notice of this hearing, sent to us on or about August 8th of this year, specifically requests that we provide additional information, stating, quote, in addition to any arguments relating to penalty that the parties may wish to submit, it would be helpful to the board if the parties specifically address the following issues, if the parties specifically address these issues such as in their arguments, number 1, protection of the public, number 2, the circumstances surrounding the misconduct, number 3, the likelihood of the misconduct recurring, and number 4, any mitigating factors that the board should consider, including factors that may be considered as extenuating or reducing the degree of moral culpability, end of quote. This we have done in Dr. Adorcio's submissions and today in this presentation. Dr. Adorcio has not introduced new evidence, nor has he relitigated the issues already decided, nor attempted to persuade the board to change any of the previous findings. Rather, Dr. Adorcio has provided the board with salient information to assist in reassessing the penalties previously ordered in light of the Superior Court's previously ordered reversals. How can this board possibly reassess the penalties as the Superior Court required without first knowing what Dr. Adorcio has or has not done in terms of complying with the penalties previously ordered? Certainly, the Superior Court desired, if it desired, it could have affirmed the penalty assessed. It did not. Given that several of the factual findings were overturned as against the manifest weight of the evidence, then it necessarily follows that the Superior Court intended for this board to lessen the penalties previously ordered. The board is entitled to know and consider what measures Dr. Adorcio has undertaken. Certainly, given the extraordinary step taken by the Superior Court in reversing 4 of the factual findings and order a remand to the board, it is essential to bring to this board's attention mitigating or other circumstances such as Dr. Adorcio's early acceptance of responsibility, demonstrated willingness to undertake board-ordered rehabilitation, the fact that the misconduct occurred more than 6 years ago, and most importantly, what changes Dr. Adorcio has made to his practice to ensure the public's protection. We're here to explain why Dr. Adorcio is confident that the issues that were criticized and supported by the evidence will never happen again. Realize, please, that for the past 35 years until these proceedings, Dr. Adorcio had an unblemished record in California. Since coming to California in 2005, he's treated more than 4,000 patients and has had no prior disciplinary action against him, nor any malpractice claims against him. In addition to learning the carotid endarterectomy, or CEA procedure, from the father of cardiac surgery, Dr. Michael DeBakey, who invented it, he has accomplished a stunningly low combined stroke and mortality rate of less than 1%. The guideline rate to be permitted to perform this surgery in most facilities in California is 3 to 6% combined stroke and mortality rate. So he has performed more than 1,300 CEAs, and the only 2 patients Dr. Adorcio has ever lost in doing a CEA are the 2 patients at issue in the prior board proceedings. Dr. Adorcio is asking this board to revise the terms of his probation so that they are more appropriately tailored to him and his practice and the deficiencies that were identified. All the terms unfairly apply to his practice as a whole, and thus are overbroad, given that the CEA procedure is the only surgical procedure at issue in these proceedings, and this procedure comprises but a small part of his overall current practice. Dr. Dorcio immediately undertook board-ordered rehabilitation as set forth in the probationary terms. Terms 1, which required Dr. Dorcio to participate in the PACE program. I'd like you to know that although he completed phase 1 of the program, it did not assess him as it is supposed to in the practice areas in which he was found to be deficient. Rather, he was required to take a general surgery examination, despite the fact that he's never practiced general surgery, and these procedures did not involve general surgery procedures. He was also improperly required to participate in ER scenarios involving drug overdoses, cases that have nothing to do with the treatment at issue here. Currently, Dr. Dorcio is waiting to hear what phase 2 will entail. No one at PACE can explain to him how they intend to instruct or rehabilitate him further, perhaps because the circumstances for which he was sanctioned do not readily fit into the typical training provided at PACE. Since neither Dr. Dorcio's surgical skills performing CEAs, nor his ability to read and interpret imaging studies regarding CEAs were found deficient. Term 2 requires Dr. Dorcio to take a medical record-keeping course, which he completed immediately after the board's decision became effective. Term 3 required Dr. Dorcio to complete an additional 40 CME hours annually. Dr. Dorcio has already completed those hours for the first year of probation in advance of the 1-year anniversary of the decision becoming effective. Term 4 required him to have a practice monitor, which he retained about 1 month after the decision became effective, and who has given Dr. Dorcio stellar reports on everything the monitor has reviewed. Term 5 prohibits solo practice. Dr. Dorcio has been in compliance with this term and intends to continue to be. However, just a mention of the 2 terms, practice monitor and no solo practice, during the ordered probation has condemned Dr. Dorcio from succeeding in applications he has made for new employment, insurance panel coverage, and hospital privileges. These have become punitive as applied and are a reason why Dr. Dorcio is seeking to revise the terms. He would like to continue to treat patients in need of his services in a relatively underserved rural area of Northern California where he practices without such barriers. The reasons why Dr. Dorcio requests you to revise the probationary terms are detailed on pages 11 through 14 of his written argument, and due to time restrictions, they'll be only briefly discussed now. It has been 6 years since the cases at issue took place, and since that time, Dr. Dorcio has not received any reports of concern or any other complaints about his care of his patients. He has performed hundreds of operations since that time with no strokes, no mortality stemming from carotid surgery. Complainant is absolutely wrong in his statement, and I quote, that absent monitoring, there's no reason to believe that respondent will conduct his practice any differently in the future, as he insisted his actions were proper in all respects, end of quote. Dr. Dorcio's actions prove otherwise. He has made significant improvements in his medical record documentation. They are more complete, more explanatory, accurate, and timely. With respect to each of the deficiencies identified by the board unrelated to medical record keeping, Dr. Dorcio has put in place safeguards in his practice which make having a practice monitor and a solo practice prohibition unnecessary. I'd like to address some extenuating circumstances during the prior disciplinary proceedings. Throughout the disciplinary proceedings, including the initial board interview and the evidentiary hearing, the stress and pressure of trying to help his young son, Andrew, who had metastatic cancer, consumed Dr. Dorcio. He took Andrew to every single cancer treatment appointment in distant cities all over the country. He stayed with Andrew when he was in the hospital, assisted in Andrew's treatments, and continued to try to work full-time, yet always be available for his son's needs. Due to the tremendous strain on him personally, Dr. Adorcio was not able to properly participate in his own defense. At the initial board interview, some of the statements he made were not as coherent as he would have liked, nor was he prepared as he should have been. To be clear, though, Dr. Adorcio never changed any statement he made to the board agents, nor did he have any intention of being anything other than completely truthful. His son passed away just 2 months following the evidentiary hearing. In conclusion, since the treatment at issue, the demands of Dr. Adorcio's personal life have changed dramatically for the better. He has definitely learned a great deal from these proceedings and has corrected and eliminated the deficiencies in his practice that the board identified. While Dr. Adorcio does not expect the board to excuse his past conduct, he is hopeful that he will have a chance to continue to practice medicine without the many restrictions which have become obstacles thwarting his practice. Dr. Adorcio asks the board to reduce the 5-year probation to 1 year. As he has complied with all aspects of the board's decision and is hopeful the board, in its reassessment, recognizes that he is rehabilitated and will consider these extenuating and mitigating factors and reduce and revise the terms of the probation as requested here and in the written argument. Dr. Adorcio would also like to make a brief statement and will respond to any questions you may have. Thank you for your attention, and on behalf of Dr. Jim Adorcio, for your consideration.
Right at just about 2 minutes, so Dr. Adorcio, please.
Could I save my comments till after the follow-up?
Ken, we only have 5 minutes, so.
Okay.
Oh, 10 minutes altogether, correct?
No.
20 minutes?
No, you have 15 now, and you'll have 5 once the,
But I just used 10, right?
no, 13.
Oh, I used 15?
But that's, okay. I mean, you can use the full 13, I don't think you carry over.
Oh.
So it's going to be 5 minutes for.
Or I could, okay, I don't want to interfere with Dr. Firestone's comments at the end, so maybe I should just give my statement.
It's up to you.
Well, I'll do that as quickly as I can. I actually have timed this, and it's probably closer to 4. Is that okay?
Well, you're only allowed 15, so
Okay.
so they got 2 left.
Thank you. I appreciate the opportunity to be here and speak to you, and I have notes in front of me to try to stay on this timeline. I've been a cardiovascular and thoracic surgeon for 35 years, and I, like all other physicians, have dedicated my life to my patients, and they mean everything to me. I've been very fortunate that I was educated in residency trainings and fellowship trainings over the country at some of the best training centers in the world, and with some of the best surgeons. And up until this moment, I had a pristine practice for 35 years. I have taken to heart the board's criticisms and the mere fact that I was accused, let alone found guilty, of having patients that were treated not in the most medically appropriate way, devastated me. And I have listened to the board. I have learned from this. I accept responsibility, and I corrected these deficits. I understood that the board findings, and I immediately took actions to change this. I committed to the educational process with the medical records courses. I've also gone on to do CMEs that were required, and I've already done more than twice the number required for this year, and I will continue that commitment. I really want the board, though, to understand how my practice has changed since 2010. At that time, I was covering 4 different hospitals for cardiovascular and thoracic call. I would have one partner. I was on call every other night. I was also doing all of my documentations by hand. And I was taking care of my son, who at that time was a teenager battling recurrent metastatic Ewing sarcoma. My practice and my life is completely different today. I work out of a single hospital. I do not take a call for cardiac surgery anymore. And I use electronic medical records. So everything is in real time and immediately documented. There's no second guessing my rationale, my surgical plans. I did hire a practice monitor, and I have not only turned over the required information that the board, one thing to have, I turned over every single surgical procedure and have had pristine reports for this past year. Now, and very importantly, I applied 7 safeguards so that I would have zero likelihood of ever having the carotid surgical patient ever fall below the surgical standards. I do preoperative imaging studies that I was criticized about. Any patient who has less than 80% stenosis by an ultrasound gets a CAT scan, so they get 2 images before they're found to be appropriate. Every patient that I determine should have surgery, I send them to a neurologist, a non-surgeon, to get a second opinion, make sure they agree with my interpretation of that patient being a surgical candidate. That was not required by the board, but something very important in my practice. I also do what's criticized about postoperative completion imaging, and every single patient gets an intraoperative and a postoperative completion imaging study, and it's recorded in their chart. I also do the same thing with my assistant. I always record in the chart now who is my assistant, a surgeon or a surgical assistant on every single case. And then finally, regarding classification of patients with syncope as a symptom. This is a controversial point. It was brought up as a discussion in these cases, and I just have the neurologist be the one who determines if syncope is a symptom of that particular carotid patient. In closing, I really want the panel to understand though, that of all the cardiac, thoracic, vascular, and endovascular procedures I've done over 35 years, and at dozens of hospitals, there's only one hospital and only this one procedure that I was ever criticized about. And currently, I do about 2 carotid endarterectomies a month. I see another 125 to 150 patients a month, and most of these patients don't have surgery. They're wound care, they're vascular evaluations. But my probation interferes in every aspect of all my patients' care. Now, it has been 6 years since these occurrences, and I've been a completely different surgeon today than I was. I have completely different practice, and I've eliminated all the deficiencies that my practice at the board identified. I serve a very rural area in Northern California where there is not another vascular thoracic surgeon for 50 miles south of me and maybe up to about 300 miles north. And in terms of probation,
I'm allowed to go a little over, but I have to ask you to.
last sentence, again, just with great humility, I ask the board to please consider the statements made by my attorney, and if there's any way to modify my probation, I would greatly appreciate it. This would be for myself and, of course, for my patients.
7.
Thank you. Despite what we just heard from the respondent, this case was sent back to the board for the purpose of considering the appropriate penalty given the findings that were upheld. It was not sent back to reconsider. That's an important distinction. The majority of the petitioner's or the respondent's argument and his briefing treats this proceeding as if it were a petition for reconsideration, or as if it were a motion for reconsideration, or early termination, and that's not what this proceeding is. This is not the opportunity to relitigate the findings that were upheld, or to argue that there were no deficiencies in this case, because this was a very serious case. 2 patients died, and 1 patient had a very risky surgical procedure done where there was no clear medical indication. The board's decision lays out in great detail what findings were made against the respondent, and the Superior Court, after conducting a meticulous review, upheld the vast majority of the serious findings. The Superior Court upheld the fact that there were 3 separate findings of gross negligence, 7 findings of repeated negligent acts, 2 findings of incompetence and inaccurate and inadequate record keeping. And there were 5 patients at issue in this case, and there were findings that were upheld for all 5 patients. And the court determined that only 3 minor findings were not supported by the evidence, and essentially what they were 2 simple departures and 1 record-keeping violation. So given that the Superior Court upheld virtually all of the more serious findings, the penalty should remain the same. And so subtracting the 3 minor findings doesn't change the outcome. And if we were just to look at one case, and that would be the case of patient SB, we would have the same outcome. So just to briefly go over the highlights of the care that was provided, the deficient care that was provided to patient SB, is that patient underwent a very complicated surgery, and he suffered a post-operative stroke. After the stroke, from that point forward, Dr. Odorizio basically did nothing for that patient. There are no notes that document an evaluation of the neurological condition. There are no treatment notes. There is no plan. It was not until the following day after the patient suffered the stroke that another physician ordered the appropriate imaging studies and neurological examination. And again, the court upheld all of those findings, those gross negligence findings. So looking at just that patient, the disciplinary guidelines would call for the terms and conditions that were set forth in the board's decision. And the respondent has argued that the terms and conditions were not tailored to this case. Nothing could be to the contrary. They are squarely on point, and they do address the deficiencies at issue. For instance, there's the requirement that the respondent undergo PACE, and that is still reasonable and necessary to identify any issues with competency and to also identify any appropriate remedial training. Here we have a respondent who was found to have a lack of knowledge, and that was for purposes he was unable to determine what made a patient symptomatic for carotid endarterectomy purposes. And in addition, he has to this day never offered a logical explanation for the discordance in his stenosis. It could be a lack of knowledge, it could be carelessness, it could be lapse of judgment. We really just don't know. And the practice monitor and the no solo practice condition are also important in this case because we have a situation where the doctor performed a procedure on a patient where there was no clear medical indication, and that's very concerning. And all of this combined with the fact that he has refused to admit that there were deficiencies in his practice. Today, he did say that he accepts responsibility, but that is actually contrary to the evidence. There's still this minimization of the deficiencies that were identified, and I wanted to provide a couple of those examples because it's actually very troubling for him not to have the insight at this point. For example, during the hearing, Dr. Odorizio testified that he did not consider his care of patient SB, which we just discussed, to have been deficient in any manner. He went as far as to argue that it was the patient's wishes to not be treated after the stroke. However, there was not a shred of evidence in the record that suggested that, and there was no evidence that at that point in time when the patient suffered the stroke that he thought the patient was a hopeless case, or that he had had a consultation with a family member, or that there was an advance directive. In addition, he argued at the hearing that he in fact did accurately document the degree of stenosis for patient RB and SD and DC, but in fact the evidence couldn't be anything more to the contrary. He also argued that the inaccurate reporting of stenosis does not affect a patient's health in any manner. The testimony from the experts all across the board stated that that was incorrect and that it would impede a patient's continuity of care and affect them for the rest of their lives. He also continued to argue throughout the hearing and through the writ proceeding that patient SD and DL were in fact symptomatic for CA purposes, and the list goes on and on. But the bottom line is that these probationary terms and conditions that are set forth in the decision are appropriate, they're necessary for public protection, There was a suggestion by a respondent today that the Superior Court felt that this was maybe not an appropriate penalty, but if you look at the order, the court actually did not say that. There was no suggestion that the penalty was not appropriate. They found that actually the findings were not inconsequential as a matter of law for purposes of the board's corrective action. Also, we heard the respondent argue that the terms and conditions were basically a cut and paste job. That is also incorrect. Had it been a cut and paste job, if you look at the disciplinary guidelines, he would have also had to have a billing monitor. But there wasn't any evidence of falsifying of records, so that wasn't applied to him. In addition, they did not require that he have to take the ethics program, because there wasn't a finding that there was falsification or intent in falsifying the stenosis. He also mentions that he now has a self-appointed neurologist to look over things. Unfortunately, while that's commendable that he's doing that, what needs to happen is we need to have a board-appointed practice monitor who has an obligation to report to the board about what's going on, to make sure that the respondent is exercising the proper judgment and performing surgeries with clear medical indication. And this self-appointed neurologist doesn't have that obligation and could stop at any point. To segue, I wanted to also mention that we feel that the respondent has, in his briefing and in his argument today, mentioned a variety of matters that are outside of the record. And we would object because it's not properly before the board. And the respondent knows this. He was issued 2 notices that reminded him that only matters that were in the record could be considered, no new evidence. However, despite that, in his briefing, and you heard today, he references the doctor's performance in PACE. Clearly that occurred after the hearing. And where we are today, we leave off where the hearing concluded. Beyond that, it's really not relevant. And while we object to the reference to PACE and his performance, we'd also point out that we have reviewed those PACE results, and they are not as represented by the respondent. And he also references changes in his documentation practice. Again, that's good to hear that he's complying and that he's made some changes. But again, that's outside the record. And what it does show is that probation is working and that he is improving his practice. That's what we want. He also mentioned that there's a hardship for him in terms of the terms and conditions. That is not a relevant factor in these proceedings. And in fact, they were excluded by the ALJ at the hearing. And when the respondent tried to bring up the hardship defense in the writ proceeding, the Superior Court shut him down and did not permit that. So the bottom line here is that this was a very serious case, and these terms and conditions are tailored to the deficiencies that were identified, and there were numerous. And for public protection's sake and for the doctor's own rehabilitation, the terms and conditions that were already imposed are appropriate and necessary.
Arthur, you have 5 minutes.
Thank you, Your Honor. In the underlying case that Ms. Evans addresses her remarks to, keep in mind that we are not asking for those findings that were supported by the evidence to be in any way reconsidered. In that underlying case, Dr. Adorsey was entitled to defend the allegations against him with competent expert testimony at that trial. It was a battle of the experts. And we had experts who were professors, associate professors from University of Chicago, from Stanford, and their positions, some of which were accepted by the administrative law judge and the board, some that were not. Dr. Odorcio is not asking you to reconsider the facts that underlie the evidentiary findings that he accepts fully. And we have not minimized those findings at all, as Ms. Evans has alleged. Ms. Evans states that there were only 3 findings reversed. That is not true. I will quote from the decision by Judge Quinn. He states that Dr. Odorcio had demonstrated that the board's finding that he was negligent in performing a workup of patients BL and also patient SD are contrary to the weight of the evidence. That's 2. The Superior Court said that as to SD, another patient, Dr. Odorcio was negligent in that he failed to explain his finding of an 80% stenosis, or why his analysis differed from the radiologist analysis, is not supported by the weight of the evidence. That's 3. And he goes on to state, this is on page 2 and page 3 of the decision for remand, that regarding BL, he failed to maintain adequate records in violation of Business and Professions Code section 2266 by failing to accurately report BL's carotid duplex results is contrary to the evidence. That's 4 findings that the Superior Court reversed, not 3. Now, the judge in the Superior Court also said that the board should reassess the penalty. Now, Ms. Evans is playing with semantics here by saying that you're not to reconsider the penalty. Reassess the penalty and reconsider the penalty, I don't think is much different. We're not asking you to reconsider any of the remaining findings that were supported by the evidence. Consequently, everything that Dr. Odorcio stated and I stated earlier is valid, and we ask you to reconsider, not change the findings, but reassess the penalty as we have suggested, because at this point it is punitive and the board is not allowed to be punitive. They're devoted to education and protection of the public, and I think we have covered those very succinctly for you this morning and in our written argument. Jim, do you have, we still have time? Would you like to say
1 minute. 1 minute.
I did want to emphasize again that, as I said here today, I have a practice that obviously has evolved and changed dramatically than where it was 6 years ago. There is no way it would go back to that. I would not abandon electronic medical record keeping. And most obvious, my life has completely changed. I, as I said, have focused and simplified my practice. My son did pass away during the hearings shortly after, and that alone was, after 7 years of battling cancer, was a tremendous change in my family's life and my practice. And with that, going forward, I just want to have an opportunity to help. I've reached patients that have Medicaid partnership and insurances, and I cannot participate in health care.
There isn't anybody in this room whose heart does not go out to Dr. Odorcio for the tragic circumstances that he references regarding his son. However, as the ALJ noted at page 26 of her decision, those circumstances, they do not excuse or mitigate the violations. And it just cannot be emphasized enough how many of the findings were upheld in this case. We're talking about, again, gross negligence, repeated negligence, incompetence, and record keeping. So the fact that, 2-3 simple departures and 1 record keeping was not upheld does not change the fact that the guidelines call for the terms and conditions that were imposed. And it's not meant to be punitive, it's meant to help the doctor rehabilitate, to have him improve his practice, which we've heard it's actually working. He's changing his ways, and it's also meant for public protection. That's actually the most important reason. So, in closing, we would just request that the board keep the same penalty as set forth in the decision.
Any questions from the board?
Thank you.
Thank you. The board will now go into closed session. All unauthorized persons must leave the room. Thank you very much.
Federal Board of California. We will hear an oral argument on the proposed decision regarding Dr. Christopher Thomas Thompson. Judge Boyle.
Thank you. I'm going to call the matter of the petition for reinstatement of Christopher T. Thompson, case number 800-2014-008947, OAH case number 2016-040891. May I have appearances, please?
Yes, Bruce Landau, L-A-N-D-A-U, on behalf of Dr. Christopher Thompson, who's seated to my right.
Good morning, members of the board. Lieutenant Attorney, Deputy Attorney General, on behalf of the people.
We're here this morning to hear argument on the board's non-adopting of a proposed decision. Mr. Thompson and his representative will have 15 minutes to give their presentation. Deputy Attorney General Tran will then have 15 minutes to present his presentation, after which, again, petitioner Thompson has 5 minutes for a closing statement, and Mr. Tran will then have 5 minutes for a closing statement. Does Mr. Thompson intend to speak to the board?
Yes, we will take a portion of our time for Dr. Thompson to speak to the board.
In that case, I'm going to swear in Dr. Thompson. If you please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Landau, you're ready.
Yes, I just want to make sure that we had submitted a written argument and want to make sure the board had an opportunity to review the written argument.
Yes.
Thank you. This is not an issue with regard to medical competence. Dr. Thompson has been admitted in the state of California and has practiced emergency room medicine and for over 32 years without any incident of any issue with regard to his medical competence. This case arose out of a car incident in 2008. Prior to 2008, he practiced an unblemished record in medicine. And even after the car incident that occurred on July 4th, 2008, until he was convicted, he also practiced emergency room medicine without any incident. The issues involved here resulted out of a car incident in Mandeville Canyon back in July 4th, 2008. Dr. Thompson, after that incident, immediately began psychological examination and anger management classes, and since that time has rehabilitated himself in terms of how he controls his emotions. This reinstatement, the presentation to the administrative law judge, issued a ruling that required certain conditions for Dr. Thompson to have his license reinstated. Dr. Thompson is in agreement with those conditions, which are substantial and onerous, including the PACE program, including someone monitoring him and psychological profiling him, and he is in total agreement with the administrative law judge's position. We're uncertain as to why the board would not adopt the administrative law judge's position, which does provide all of the conditions to protect the public. Dr. Thompson is not a danger to the public. He has practiced medicine without incident with the public. And in fact, the incident that was involved in July 4th, 2008, he tried to render aid to the individuals who were injured at the scene of the accident, and who refused him allowing to assist them with their injuries. We don't believe there's going to be a reoccurrence of any of the events that occurred on July 4th, 2008. Dr. Thompson is fully capable of practicing medicine competently. While his license was revoked, he did continue with medical education, spent substantial hours maintaining his skill level by continuing to study medicine and be prepared for the time when he can be reinstated as a physician. At this time, I'd like to let Dr. Thompson make a brief statement.
Thank you to the board and for your time and for consideration. This auto accident with bicyclists was a tragedy. I freely admitted it was a mistake. But surprisingly, no one throughout this entire process, including all the hearings in court, before the board, anybody has ever asked me what the root cause of this was. That was surprising to me, so I'm going to voluntarily tell you what I think the root cause was, because I've had about 7 years to think about it, study it, discuss it with lots of other people. This was a tragedy primarily because I spent my entire life trying to help people, and now I was the exact cause of injuries that I've seen so many times in the emergency department and shaken my head, how could this happen? So what was the really root cause? Why did I stop and they run into the back of me? The newspaper said it was road rage. It was not. This had been going on for 9 years in my community. The real root cause of this, I believe, was basically my stupidity in thinking that I can control all incidences. In the emergency department, when people come to see you for care, to a large degree, you control their lives for that period of time. You control their outcome. And as physicians, I think we do that in lots of capacities, but in particular in the emergency department, that's what genuinely or routinely happens. I let that kind of control spill over into my personal life and my non-professional life. I thought I could control all incidences, and I've spent a lot of time realizing that this isn't the way life is. You just can't control it. This is an incident that had been ongoing for 9 years, like I said, between bicyclists and the board of the homeowners association where I live. Nothing had happened from it, primarily because Los Angeles Police Department couldn't identify the bicyclists. Finally, they told us, get a picture of them and we'll be able to see who they are. I took them at their word and I stopped to try and take a picture. I stopped too quickly. One of them hit the back of me, the other one hit the back of him, and the bottom line is 2 of them were injured. Neither was admitted to the hospital. They were both discharged home, one with a separated shoulder and the other with an open laceration of the nose and a chin laceration. I am profoundly, profoundly sorry that I was the proximate cause of somebody else to be injured. That has never happened to me before. And I've spent the last 7 or 8 years basically trying to make up for that by not trying to control all incidences. That's my story, and I'm sticking to it, as the song says. I appreciate your time and your consideration.
Anything further, Mr. Lackadown?
Nothing further.
City Attorney General Trent?
Yes, thank you, board members. I appreciate Dr. Thompson's story, but with all due respect, of course, the root causes are irrelevant. I don't want to relitigate the criminal matter. The purpose of this proceeding is patient safety, public protection. He hasn't practiced medicine in 7 years. Now let's just use common sense. When I'm on vacation for 2 weeks, I forget things. ER medicine requires split decision decisions, and medicine is an ever-evolving science. That's why doctors have to take continuing education. That's why lawyers have to take continuing education. So competence, with all due respect to counsel, he says competence is not an issue. It is an issue in this case. Competence is the salient issue in this case. That's because Dr. Thompson has not been practicing for 7 years. And when there's any doubt whatsoever whether he can resume his practice safely with patients, I would respectfully request that the board err on the side of public protection. And that's what I'm doing here. And I believe that the recommendations that I made, that he passed the PACE program as a condition precedent with psychiatric testing, that's the minimum. That's reasonable to protect the public. And I would also want to add that I made the recommendations at trial because I misunderstood Dr. Thompson's future intentions. Dr. Thompson, if I remember correctly, Dr. Thompson stated that he was working for a medical software company. I misunderstood that to mean he wasn't gonna resume patient care, especially ER, which requires split decisions to make. Had he made it clear and had I understood it correctly at hearing, I would have recommended further terms like a practice monitor, no solo practice for at least 2 more years. So I think that's very reasonable. I commend him for his efforts, but as I stated, the root causes are irrelevant, shouldn't be an issue in this proceeding. The issue here is patient safety.
Wanda, you have 5 minutes.
Yeah, just one point. With regard to practice, Dr. Thompson has never practiced as a solo practitioner, doesn't intend to practice as a solo practitioner in medicine. To the extent that there are conditions that have been enunciated by the administrative law judge, we are totally in agreement with all of those conditions for purposes of reinstating his license. We are not objecting to findings of the administrative law judge, and we believe the public will be protected. Dr. Thompson has maintained his level of education by continuing medical education, even though he doesn't have his license. He's maintained his ability to practice medicine in terms of his knowledge and his skill levels. And we believe it is appropriate for him to have his license reinstated, subject to the conditions as enunciated by the administrative law judge. Thank you. I think Dr. Thompson wants to add one.
I'd just like to add the notion that I haven't practiced medicine. I've probably know more to your chagrin about ICD-10 coding and things of that nature than anybody in the room. Because I basically have been for the last 3 years doing software companies, created, designed, and developed software. I have not practiced clinical medicine, and there's a fairly high likelihood I probably won't again. I need to have my medical license reinstated primarily because software companies in particular, that's one of the requirements. I have stayed up very actively with medicine. I continue to do that. Would I ever clinically practice? The thing that I would like to do clinically more than anything is missionary work, not in this country. But bottom line here is I have been staying up with medicine.
Anything further?
We have nothing further.
Jan, 5 minutes.
Yes, again, with all due respect to counsel and Dr. Thompson, I respectfully request that the board err on the side of public protection if there's any doubt whatsoever. I can just, again, use common sense. Studying courses is different from actual practice. Studying the bar taking the bar did not really, I'll be honest with you, did not help me in my practice in medicine. Just by taking courses is totally different from examining a patient that requires split decision, life-changing decisions by the doctor. So just because he's read up on journals and stuff, that's irrelevant. Again, I want to focus the board members to what's salient in this type of proceeding. That's patient safety. If there's any doubt whatsoever, you should err on the side of patient safety.
Any questions from the board?
Yeah, Dr. Thompson, in the record, and I'm going to read from the record, it says, at hearing, petitioner reiterated his desire to practice medicine again, as it has been his passion since he was 17 years old. Specifically, petitioner's father was a trauma surgeon and served as an example of how to best serve others through the practice of medicine. In addition to earning a living again as a practicing physician, petitioner would like to perform medical missionary work. Petitioner asserts he is fully capable of integrating back into the medical world. That is at odds with what you're saying now.
Not really. I think the practice of medicine divides effectively into clinical and non-clinical practice of medicine. The reality is I would love to be able to practice clinical medicine again. The real reality is, though, is getting hired to do that is probably unlikely. Possible, but unlikely. The non-clinical practice, I have a lot of, about 30 years worth of experience, in particular in medical computer software and education, and that's more likely my practice track, frankly. Hope that answers your question.
Any other questions from board members? Thank you. We'll go into closed session.
Thank you.